Good evening, friends. Let us dive into another case law, which is newly added into the advocate or court examination. Friends, I am talking about case law Abhiram Singh versus C.D., which was decided on 2nd January 2017. Friends, this case revolves around the interpretation of Section 123 supply 3. So let us dive further. What is the majority view? It said that the conflict between giving a literal interpretation or a purposive interpretation to a statute or a provision in a statute is perennial. It can be settled only if the draftsman gives a long-winded explanation in drafting the law, but this would result in an awkward draft that might well turn out to be unintelligible. The interpreter has therefore to consider not only the text of the law, but the context in which the law was enacted and social context in which the law should be interpreted. Secondly, it said ordinarily, if a statute is well drafted and debated in Parliament, there is little or no need to adopt any interpretation other than a literal interpretation of the statute. However, in a welfare state, what is intended for the benefit of the people is not fully reflected in the text of the statute. In such legislations, a pragmatic view is required to be taken and the law interpreted purposefully and realistically so that the benefit reaches the masses. Of course, in statutes that have a penal consequence and affect the liberty of an individual, or a statute that could impose a financial burden on a person, the rule of literal interpretation would still hold good. The Representation of Peoples Act 1951 is a statute that enables to cherish and strengthen democratic ideals, to interpret it in a manner that assists candidates to an election rather than the elector or the electorate in a vast democracy like that of India would really be going against public interest. The purpose of enacting subsection 3 of section 123 of the Act and amending it more than once during the course of first 10 years of its enactment indicates the seriousness with which Parliament grappled with the necessity of curbing communication, separatism, and vociferous tendencies during an election campaign, and even otherwise, in view of the amendment of Section 153A of the IPC. It is during electioning that a candidate goes virtually all out to work to seek votes from electorate, and Parliament felt it necessary to put some fetters on the language that might be used so that democratic press is not derailed but strengthened. Taking all this into consideration, Parliament felt the need to place a strong check on corrupt practices based on an appeal on grounds of religion during election campaigns and even otherwise. The concerns which formed the ground for amending Section 123, subclause 3 of the Act have increased with the tremendous reach already available to the candidates through the print and electronic media, and now with access to millions through the internet and social media, as well as through mobile phone technology, none of which were seriously contemplated till about 15 years ago. Therefore, now more than ever, it is necessary to ensure that provisions of the subsection 3 of section 123 of the Act are not exploited by the candidate or anyone on his or her behalf by making an appeal on the ground of religion with a possibility of disturbing the even tempo of life. Keeping in view the social context in which subsection 3 of section 123 of the Act was enacted and today's social and technological context, it is absolutely necessary to give a purposive interpretation to the provision rather than a literal or strict interpretation that is limited only to candidates' religion or that of his rival candidates. The provisions of subsection 3 of the section 123 of the Representation of People Act 1951 are required to be read and appreciated in the context of simultaneous and contemporaneous amendments inserting subsection 3A in section 123 of the Act and inserting section 153A in the Penal Code. So, read together and for maintaining the purity of the electoral process and not vitiating it, subsection 3 of the section 123 of the RP Act 1951 must be given a broad and purposive interpretation, thereby bringing within the sweep of a corrupt practice any appeal made to an elector by the candidate or his or by any person with the consent of a candidate or his election and agent to vote or refrain from voting for the furtherance of the prospects of the election of that candidate or for prejudicially affecting the election of any candidate on the grounds of religion, race, caste, community, or language of any candidate or his agent or any other person making the appeal with the consent of the candidate or elector. So it is a matter of evidence for determining whether an appeal has at all been made to an elector and whether the appeal, if made, is in violation of the provisions of subsection 3 of section 123 of the RPA 1951. There was some uncertainty about the correct interpretation of subsection 3 of section 123 of the Act. It is not as if the interpretation was well recognized and settled. That being the position, the court can unsettle the long-standing interpretation given to section 123 subclause 3 of the RPA Act. So this is all about, friends, today's video. I hope you are enjoying my videos. Thanks for watching. See you again.